Hello, guys, and welcome back to our YouTube channel. So in the last discussion, we talked about wills, the part one of wills and codicils. We talked about the types of wills. We talked about the meaning of wills. We talked about the advantages of having a will, and we also talked about testamentary capacity. And we promised to continue on with testamentary intentions. Now we'll continue from there. To make a valid will, a testator must possess what is referred to as the animus testandi, an intention to make a will, to know and approve of the content of the will. Right? Now, under the will, there's also what we call due execution. See, execution generally means signing of the will, bringing the will into effect. But there must be due execution. And when we talk about due execution, and that's what we're going to talk about right now, there are some steps or some things that must be present before it can be said that the will was duly executed. Now, one of it is that, one, a will must be in writing. Two, a will must be executed. That is signed by the testator. Testator, like I said in the first video, in the other video, is the person who makes the will. A will must be in writing, must be executed by the testator. It need not be usual signature of the testator, but it must be executed by the testator. It must be attested to by two witnesses, at least two witnesses. Then the attestation must be in the testator's presence. Now, what are the modes of execution? One, by testator signing personally or acknowledging signature, or testator directing another person to sign on his behalf and in his presence. For the purpose of your objective questions, for those at the law school, it is important to remember this. The modes of execution of a will are, one, by the testator signing personally, or the testator acknowledging signature, or the testator directing another to sign on his behalf and in his presence, in the presence of two witnesses present at the same time. Now, that point I just made is very important. The two witnesses that are signing or attesting must be present at the same time. Look at section 9 of the Wills Act of 1837, which, as I had earlier said, is a statute of general application. Also see section 4 of the Wills Law of Lagos State. Now, attestation. These are what I'm going to tell you now are the steps for a valid attestation. Right? One, for the witnesses, the witnesses must be physically, I told you that the witnesses has to be two at least. Now, these two witnesses must be physically and mentally present. They need not know the knowledge of, they need not know the knowledge of the content. They need no knowledge of the content of the will. They need not subscribe in the presence of each other. Blind person cannot attest, but they can make a will. Look at in the case I cited earlier. A blind person cannot attest to a will, but a blind person can make a will. Again, a blind person cannot attest a will, but a blind person can make a will. Right? Now, section 9 of the Wills Act talks about the attestation clause. It may be long or short, right? It may be long or short, so there's no specification on that. Then a beneficiary or a spouse of the testator is not to attest to the will. It's not to witness the will. So if you are benefiting from the will, so let's say, for example, one of the witnesses is a brother of the deceased or the testator. He can, if he's going to be a beneficiary of the will, it cannot be a valid testator, right? It cannot be a valid testator. But when you have, let's say, 5 people are testing to the will and 2 of them are beneficiaries, because the other 3 persons who are not beneficiaries also are tested, then the will is valid, right? Because you still have at least 3 valid attestators, right? So so it will be in, so I mean, the charging, this is what we call the charging clause, right? And the charging clause would read like this: in our joint presence and by us in his presence. So in case you're drafting the will, I would later in the course of this discussion teach you how to draft a will, step-by-step procedure on how to draft a will, right? Section 1 of the Wills Law of Lagos State enables a witness who is also a beneficiary to retain the benefit where there are other witnesses to prove the due execution. So that's what I just said. Where you have other witnesses to prove the due execution. So let's say, for example, I think it's important to repeat this again, or to repeat this. The law provides that you have at least 2 witnesses. Now, 5, and the witnesses must not be beneficiaries of the will. You now have 5 witnesses. 3 of them are beneficiaries. 2 of them are not beneficiaries. That still meets the test. So it still enables the will to qualify as a valid will, and it does not prevent the 3 beneficiaries who sign from taking advantage of the provisions of the will. So that is what section 8 of the Wills Law basically says. But if you have 4 people attesting to a will and 3 of them are beneficiaries and just 1 is not a beneficiary, then the will is invalid because it was not properly attested to. Because in that case, you have just 1 person validly attesting, and that does not qualify for the purpose of the law, right? So those are things that should be really understood. Now, proof of validity of a will. Sometimes wills can be contested. When people make wills and they die and the will is read or the will is admitted to probate, and the family members start fighting over different issues. Some are saying that this wasn't the true will of the deceased. Some are saying that the will was written on that jurex and all of that. So those are the kind of things that can cause a challenge of them. So how do you prove the validity of a will? A will may either be proved in its common form, which is non-contentious, or in its solemn form, which is contentious. Where there is no proper attestation clause, or the judges has any doubt as to the due execution of a will, or where the testator is an illiterate or a blind person, the proof of validity is by the use of an affidavit, which sets out the manner in which the will was read or interpreted to the testator, and the manner in which he signified that he understood and approved of its content. See the case of Regale, 1864, 164 ER 1342. Right? In that case, the testator was deaf, dumb, and an illiterate. So some of you may ask me, why should it be proven with an affidavit? An affidavit is just a mere paper. But no, an affidavit is a statement of facts, truth. And you see, the reason why affidavits are that important is because there's a punishment for lying on oath. So if the content of an affidavit is proven to be false, right, that is going to be an offense under the law. So the content of an affidavit, once sworn before a commissioner for oath, is deemed to be correct and true until it is contradicted. Now, we have the contentious form. The burden of proof lies on the propounder of the will, though it may shift to the challenger where the propounder discharges the burden, right? For this presumption to be invoked, now there's proof of, and this is usually the burden of proof, like I said, lies with the propounder, and this is usually by proof of due execution. Look at section 168 of the sub 1 of the Evidence Act, which talks about the presumption of due execution, which provides that everything basically is presumed okay, which looks okay. Everything is presumed to be fine, which looks fine. For this presumption to be invoked, the will must be regular on the face of it. 2, it must have proper attestation clause. Look at the case of Nelson against Akofirami, right? So the first way to prove in a contentious form, a contentious will by the propounder is by proof of due execution. Then 2, by positive affirmative evidence. So oral and documentary evidence is admissible. Statements which have to do with perhaps statements at the time of instruction and execution, witnesses, evidence of conduct before and after making the will. Look at the case of Maja and Johnson. Maja is spelled M-A-J-A. Evidence of general habits and course of life of the testator. Medical evidence by a medical doctor who have attended to the testator in the past. Look at the case of Adebajo and Adebajo. Now, we'll have to talk about the classification of gifts. Under the will, the testator will say, I give this gift to so and so, I give that one to so and so, I give that one to... So there are classifications. What are the classifications of gifts? We have the device and we have the bequest. The device has to do with the disposition of real estate. For example, the man says, I give my 4-bedroom flat at there to my daughter. So that is a device. It has to do with real estate. The bequest is a disposal of or a disposition of a gift of personality, personal property. For example, when the testator says, I give my golden ring to the gate man. So those kind of things are disposals of personal property. So don't forget, device has to do with disposition of real estate. Bequest has to do with disposition of personal property. But most times they are used, construed, or interchangeably, right? And all of that. So the types of gifts, I just talked about the classifications or classification of gifts. You have device for real estate, bequest, personal property. Then the types of gifts under wills, you have general gifts, specific gifts, demonstrative gifts, pecuniary gifts, residuary gifts, right? So the general legacies, a gift not separated or distinguished from other properties owned by the testator. So where a gift does not exist at the time of the testator's death, executors must acquire it or give the money's worth to the beneficiary. So for example, when you say, I give a 6-bedroom duplex apartment in any upscale area of his choice in Abuja to my daughter MM. So those are general gifts. So he's saying, more or less saying, from my estate, provide a 6-bedroom to that person. So the testators must ensure, the executors of the testator's estate must ensure that they procure that property for the beneficiary. Now, one of the benefits of this general legacy is that it's not liable to redemption, right? The disadvantage is that it suffers abatement where the estate is insufficient. So worthless, for example, after sharing everything to everybody and there's not enough money remaining to buy the property that was given to the beneficiary, then that provision suffers abatement. The beneficiary will not get anything. It may fail where the value of the gift cannot be ascertained. That's another disadvantage, right? So we also have specific legacy. This is a gift which is specific and distinguishable from all other chattels of its kind and all other properties of the testator. It must be properly and sufficiently described. So for example, when you say, I give my gate man gold wristwatch and all of that, so those are the provisions. That's what it means when you talk about specific legacy. In the next lecture, we're going to continue with the types of gifts, right? The types of gifts under a will. We hope this video has been helpful. I mean, you can go over it, like the video, drop your comments, your questions, and also let us know the topics you want us to talk about in law, and also share the video. That will be very important. That's very important to us. And don't forget, if you have not subscribed, just click on the subscribe button. It's free. Click on the subscribe button, and then turn on your notification so that subsequent videos you'll get to know when it is released. Thank you.